Hi everyone. Welcome back to another interview of Tea with Noli IP. Today we're talking about international intellectual property law. So with me we have Luciana Noli. She's a trilingual economist who is a registered intellectual property agent in Argentina and has been working in the intellectual property area for many years in her family law firm. Her practice focuses on individuals or corporations interested in expanding their business, particularly to Latin America, as well as on clients in Latin America interested in doing business in the United States. And we also have Mariana Noli, who is the founder and manager of Noli IP Solutions.
Thank you for that introduction, Sam. And you are in charge of our digital marketing. And by the way, you're doing an amazing job. Thank you. And we also have Ari. Hi, Ari.
Hi.
So with that,
Hi.
Thank you for the introductions. We're going to get started with a presentation that Sam has put together for us. You did a fantastic job, Sam. So Tea with Noli IP, guys, and today we're going to be talking about international intellectual property law. And as Sam well said, Lucy is an intellectual property agent in Argentina. I'm an attorney in Argentina and the United States, specialized in IP law. And I've been working in this field for 16 years, over 16 years. That makes me pretty old, huh? So Sam, you have some questions for us.
Yes. My first question is it possible to enforce your copyright overseas?
Lucy, you want to take this one?
Yes, of course. Well, there is not actually an international copyright law, but actually, if as long as you are in a country that is a member of the Berne Convention or the Treaty, is it possible to do it? And actually, in most of the countries, when you create a product or when you create the invention, you have the protection. But you know, the most important thing is finally looking at the regulation of that specific country.
And I guess I would say that there is this international treaty, as Lucy very well said, the convention, the Berne Convention, that protects the copyrights. So if you protect, for example, your copyright in the United States, you wouldn't have to seek copyright protection in another country, as long as it is a member of the Berne Convention as well.
All right. My next question is, do patents apply outside the US?
Well, actually, you know, with patents, it's not automatic as it is with copyright. You have to file a patent in each country or jurisdiction that you're interested in. So it's a little bit more complicated, but you still can get the rights of the patent. And there are some treaties that you can apply for. One of them that is direct or Paris route, and you have 12 months from the first patent you file to file that patent in the other countries that are member of this treaty. And the other route is the PCT route. PCT is like an international patent, and actually you have a longer period of time to apply for each individual country. Because first you get like an international protection, and then you go through the national phase in each country.
Well, I think you're getting ahead of yourself, Lucy.
Yes, I think I did. I'm sorry.
So is a trademark protected outside of the US?
Well, actually with trademarks happen the same that with patents. You need to file a trademark in each country that you are interested in. So it is not automatically as it happened with the copyright.
Okay.
Also with trademarks, you have some treaties. I don't know if that is my next question or I just go ahead and explain this to you.
Yeah, go ahead.
Okay, Sam and Mariana. So, okay, it's like this. With trademark, you have some treaties too. Treaties with trademark are direct or the Paris route. That is the same with patents. You file a trademark in one country and then you have 6 months that if you file the trademark in the other countries, you have the protection with the same date that you did the filing of that first trademark. And the other treaty is the Madrid Protocol. And Madrid is like as an international trademark. It's a cover that if you are a member of this treaty, you get the cover in many of the countries that are members of this treaty also.
Yeah, but I guess Argentina is not a member, right?
No, actually Argentina is not a member of the PCT and is not a member of the Madrid Protocol. Okay. But you know, there is only one good thing. If you have the patent and there are two applicants in the patent, for example, one is from Argentina, but the other one is from a country that is a member of the PCT, you can apply to the PCT. And the same happened with the Madrid Protocol. If one of the applicants is a citizen of a country that applies with Madrid Protocol or has an industrial
design,
design in that country, he or she can also apply to those treaties.
Thanks, Lucy, for answering that one. Did it answer your question, Sam?
Yeah.
So the next one, we're ready for the next one.
Yeah, Daddy is ready. Sorry.
By invention in several countries.
You know, I think that this one, Lucy already answered it. Basically, that you have these international treaties that you can use to preserve your rights in several jurisdictions. But ultimately, the national offices of each one of the countries are going to reserve their rights to grant either the patent on an invention or the trademark for a brand. So you can use these tools, these international treaties, as tools to preserve your international trademark rights or your international patent rights. But eventually, you do have to file at the national level.
Okay. So what is the effect of the international patent application?
And you know, Lucy also answered this one when she talked about the PCT. It gives you additional time. So you filed an application under the PCT. This is a treaty that Argentina is not a member, but there are ways, you know, they cover several jurisdictions. So for example, you could file a PCT application and you have 18 months plus the 12 initial months for the priority. So it's at the 30th month priority is when you enter the national phase. And is that important? You know, getting that additional time, like Lucy said, it can help you a lot, because if you are starting on a project and you don't know how successful it's going to be, it gives you time to get money, to get in contact with investors, to test if your venture is going to be as successful as you want it to be. So these tools are really useful. In fact, we have several clients that use them, right, Lucy? Yeah.
Yes, of course. And actually having this extra time, as you said, Mariana, is very important, because sometimes you think that some jurisdictions are going to be great for your patent, and some of them not. And then you discover the opposite. You know, business changes as
constantly.
You go. So,
it changes constantly, yes.
So it's very important, the time.
Okay, my next question is, who has the right to file an international patent application?
Oops, I think I got ahead of this one, because you know how I said Argentina is not a member? So I don't know, Lucy, if you want to say it, but really it's just the members of the treaty, right? That they can benefit from the filing. Yeah.
Yes, one thing that is very important, I mentioned this before, that if there are two applicants or more than one applicant, if one of them is a citizen of a country that is a member of the PCT, you can go ahead and file the patent under this treaty. Or actually, if you are not a citizen of the country, but you have an establishment, an industrial establishment, like you have a society in the...
Yeah, so if you have a corporation, that's correct. So even if it's not it doesn't have to be every single one of the applicants, but as long as one of them. Yeah.
Yes.
So who can use the Madrid Protocol?
The question, you know, that's the very similar question. They have to, the applicant has to be a resident or a citizen of a member country of the agreement, of the protocol.
How much does it cost to file under Madrid?
Well, and I don't know if Lucy has much experience with the Madrid Protocol because since Argentina is not a member of Madrid, I know you have some clients that have used the Madrid, but there is a useful tool on the World's Intellectual Property Organization's website, and we have copied the link in this presentation. I love it. Lucy, have you ever used it?
Just a few times.
Yes, you select the countries and it gives you the official fees that you need to file at the national level.
And how does the Madrid Protocol work?
Well, you know, in simple terms, as long as you have a base application in a country that is member of the Madrid Protocol, then you will base your international trademark application on your base application, and you will cover several countries under the Madrid Protocol. But remember that you will have to get the application examined at the national level. The countries member of the treaty have, you know, different requirements, and they committed to accelerate the examination at the national phase. If they don't complete the examination within 12 to 18 months, then the trademark gets registered. So they only have that amount of time to raise any refusals or any reasons for rejection.
How can I find the IP laws in various countries?
Oh, this one, Luciana, I know.
Yes, well, actually, you know, you can always check the WIPO, the World Intellectual Property Office information. And over there, you can, you know, the WIPO has a lot of members, 193 member states. So actually, you have a lot of information over there. And you know, in case you need extra information or you are not satisfied with the information you find there, you can always contact us at Noli IP. That, as you can see, we have people from different parts of the world, and we are more than happy to help you.
All right, thank you for answering all my questions today.
Thank you, guys.
Bye.
Bye. Bye.